The Supreme Court with regards to the Insolvency and Bankruptcy Code. The Supreme Court has upheld the Insolvency Code in entirety. So that means that, the power producers who had written to the Allahabad High Court against the IBC, the Supreme Court has now gone ahead and upheld the constitutional validity of the IBC. Oh. Well, we have Parikshit Luthra with us. All right, we'll try to get to Parikshit Luthra. Remember,
the Supreme Court, I'll just give you some more details. The Supreme Court has dismissed the batch of petitions challenging the IBC. Now, that's as well fresh breaking news that's coming in there. They have upheld the Insolvency Code in entirety, and importantly, they have upheld the constitutional validity of the IBC. Now, those are all the statements that are coming in there. We'll try to get you, Ashmit or Parikshit, whoever's at the court right now, they'll fill us in with further details.
Absolutely. Yeah. So, it was the Independent Power Producers Association of India who had filed this petition in the Allahabad High Court for exemption from the RBI notification of Web 12, which was with regards to, recognizing the stressed assets in the sector, which amount to close to around 1.75 lakh crores as per the last number that we have. Now the Supreme Court has gone ahead and said that nothing doing, you have to recognize these as the IBC. So
I'll just Ashmit is just sending us a couple of lines. The Supreme Court has dismissed batch of petitions challenging the IBC. So basically, it says that the Supreme Court has stamped its approval on the current IBC regime, and the Supreme Court has refused pleas to allow operational creditors parity with the financial creditors. Remember, a lot of these cases, the operational creditors were saying, well, we have as big a say as the financial creditors. Now, in fact, we have, some lines coming in from the Supreme Court. They refuse pleas to allow the operational creditors parity with the financial creditors. So these are the statements that are coming in there. We have Lata as well, who will join us shortly, to give us her take on this. Lata's with us. Lata, yeah.
Yep, I think it's very important, first of all, upholding the validity. And the first statement that Ashmit has sent us from the court is that operational creditors will not get, parity with financial creditors. Now, that becomes very important because otherwise the committee of creditors will not be able to go ahead with any of the restructuring. Also, it's a clear waterfall that the first right comes to the banks, and that's the committee of creditors, and then the others. So if there's something, if you're going to get more like you got in Binani, even more than what the creditors have given, then the balance goes to the operational creditors and others. Before the creditors, the only party that has are employees who get 24 months salary. After that, it goes to the operational creditors, and even the tax authorities get only after all this. So putting that hierarchy in place and stamping approval, constitutional validity approval on this process is extremely important, and that kind of clears the way that at least we will not have one big problem of the IBC itself getting challenged. Now we have to see what the court has said about the February 12th circular, whether it removes the stay on this circular, and also whether the other power producers are able to carve out an exemption. The power producers incidentally were challenging the February 12th circular. It was certain others, even some public interest kind of people who were challenging the IBC. So actually what the court did, and it was RBI's plea as well, that you get all this under one hearing and dismiss everything together. Otherwise it's being held, the hearings are held in various courts and NCLTs. And, in one fell swoop, the Supreme Court has cleared it. We have Behram Vakil with us. There are other experts like Pramod Dev and Ashwin Parekh also joining in. But Behram, personal victory, you would say? You're a happy man?
Delighted man, Lata. Thank you so much. And I can't agree with you more. I think it's a really, really important decision for our banking sector, for the country itself. And I can't be more delighted. Okay,
what, particularly from the statements that you're seeing on TV, and I'm sure you're privy to more, your team must also be in the court today. What exactly is, positive for the banking sector and for the committee of creditors? Is it the fact that the Supreme Court has said operational creditors will not get parity with financial creditors? What particular item or items are good for banks?
No, I think, to be honest, Lata, you all have been so quick that I was just getting brief. So I know barely more than you do.
Okay.
I'm just going to get on the phone immediately to my team.
Okay.
But one is that the architecture of the statute itself has been upheld. The language of the statute has been upheld. As you said very rightly, the waterfall where the creditors come first, except for the carve-outs for workmen and the costs of the IBC, etc. So I think in general, that's a huge plus factor. And again, this operational creditor issue had been muddied by Binani.
Yes.
And I'm very glad that the court has, clarified that as well, because it was creating chaos and huge amount of delay.
No, I want you to get onto the phone with your team, get off that phone as quickly as possible and come back to us and report. But Behram, just 1 minute. What we have heard is only the challenges against the IBC. The court will eventually be also reading out its verdict on challenges to the February 12 circular?
So that our next date is on the 2nd. I'm sorry, maybe 4th, because 2nd is a Saturday.
Okay.
So 4th of Feb is our next date.
So we are not going to hear anything about Feb 12 circular today?
No.
All right. But the power producers were challenging Feb 12 circular, right?
Yeah,
not
they were,
IBC.
and but he heard it sequentially, because correctly they said that first we hear the challenge to the Act itself, and then the circular flows from that immediately thereafter.
Okay.
Unfortunately, they managed to buy some more time.
So we don't know the fate of the power producers today. We won't know.
The Feb 12 circular will be, hopefully next month we should hear that.
Okay, Feb 4th. Okay, Behram, please get onto that phone and
Thanks a lot.
and do disconnect quickly from your team so that we can get to hear, what the key takeaways are from the verdict. We have more experts, as you can see, but, the big sting has been taken out by Behram that the power producers' fate will not be known till the 4th of February. But Mr. Pramod Dev, former chairman of the CERC, is with us. Mr. Dev, good morning. Thanks for joining. Well, one part where we crucially wanted your advice and comment is not being pronounced by the court today on the power producers and whether they should get an exemption from the February 12th circular. Be that as it may, what you have heard about the IBC's constitutional validity being held, what are your thoughts?
No, well, I think when the Supreme Court has upheld the validity, I don't have anything to add. As far as the producers are concerned, power producers, obviously they have their own problems. But as Mr. Behram has very clearly said, we have to wait for Supreme Court's pronouncement on that. So again, it will be premature for me to say anything on that. But the principle always remains, because since we have been working on this expert committee for new bidding documents,
Yes.
one of the important principles is that financial institutions' interests must be protected.
Okay.
So what we have provided in these are all the drafts. Finally, the government has to approve them.
Yep.
But we have said that whenever anybody takes over a plant, then it should keep running, because there is no way power plant can be serviced
Absolutely.
unless it produces power.
Okay.
So important thing is the interest of the lender
Absolutely.
must be protected first.
Okay.
So that's why we created a two type of thing:
Okay.
infrastructure, this thing, separate entity,
Okay.
and then the plant.
All right.
That's the idea. No?
All right.
So
Got-
it's the principle.
Got your point, sir. Actually, our correspondent and our in-house legal expert, Ashmit, is with us now. And since he has got the court's judgment and was the first to hear it, Ashmit, over to you. Please tell us all that we ought to know.
Well, first up, again, the clarification that has clearly fallen from the court is that this matter was restricted to the challenges that had been posed to the IBC, legal challenges posed to the IBC, and not with respect to the February 12th circular. Those are a batch of petitions that are yet to be heard by the apex court. On the question of challenges, now what's interesting is that over the course of hearings, which were marathon hearings, it lasted a good month or so before the apex court, before Justice Nariman. One of the questions that had arisen was the role and the treatment of the operational creditors. They had cited discriminatory treatment, given that the COC, the very COC that places its stamp of approval on the resolution plan, they have no role to play there. They have no voting rights in play there. That was one of the major contentions that had been raised. And in fact, what's interesting is that during the last few hearings in the month of December, At that stage, Justice Nariman, as a part of these hearings, had in fact observed that the operational creditors require a greater role, that this entire resolution mechanism that we have in place requires the operational creditors to be given their due despite those observations. What we now understand is that what was essentially a two-sentence judgment that is given out, at least only the operative part is read out in the course of the proceedings, in the course of the judgment. What we understand is that the apex court has upheld the IBC in its entirety. In doing so, the current IBC regime has now received a stamp of approval from the apex court, from the highest court of the land. What that effectively means is that the prayer that had in fact been sought by the operational creditors, that they be treated at par with financial creditors, that there be parity between them, that perhaps even a seat on the COC and then subsequently a role to play in the approval of the resolution plan, all of those prayers have been set aside. There were a batch of 10 petitions that in fact had made similar prayers. All of those petitions have been set aside. The IBC, the way it stands currently, as had been argued by the government, has received an approval from the apex court. No questions are asked. In its entirety, the IBC has been upheld with absolutely no tweaks. Of course, the details are still awaited. These were the only two sentences approved in its entirety that in fact fell from the court. We await the judgment copy, which will give us more clarity. But as of right now, the IBC receiving the grant of approval from the apex court.
Okay. Well, actually, we know that one set of operational creditors, for instance, the home buyers have been treated as financial creditors and allowed into the COC. I guess that's an amendment to the Act and therefore that stands. As well, we would like to know if there were any specific observations on Section 29A, which involves related parties, and some of the bankers wanted that diluted to allow some of the promoters to apply. There were some challenges even to Section 12, which says that you can, with the assent of approval of 90% of the creditors, pull out a case from the IBC process itself. I don't think they were all being challenged, but Ashmit, we would await your reading of the full judgment to check whether anything further needs to be noted on these two important sections as well. Now let me get to the bankers and the people who are benefiting from this. We have Mr. V.G. Kannan, the CEO of the Indian Banks Association. Mr. Kannan, are you happy with what you have just heard? It's just the two-line verdict that my colleague read out.
I think it's the simplest and the most cleanest two-line verdict which can come. Sort of upholding the IBC process. After a long time, we had this process which actually gave teeth to the bankers to take action and the lenders. And I'm very, very happy about this. And I think it sort of quashes any kind of expectations saying that the IBC will be thrown out. And I'm very happy that the entire, as the wording says, the Upholds Insolvency Code in entirety is very pleasing to the ears.
Okay. Okay, let me get R.K. Bansal in as well, one of your former peers, Mr. Kannan. Mr. Bansal, it's just a two-line judgment, but your thoughts and what more would you want to hear from the court?
No, I think it's a very good judgment because a number of cases have got stuck up at different levels because of this. One is the Supreme Court upholding the Act in entirely, including Section 29A, because the challenges at 29A were there. The second, I think I'm happy to see the clarification on operational creditors also. So that has also caused a lot of confusion in the, overall judiciary and banking community. It will expedite, I think, some of the cases which are stuck up. So I think that overall it's a very good thing.
What did you say about 29A, sir? Was that also challenged?
I'm saying they are holding up. They have
they have upheld it, looks like.
Upheld that validity also, because that was the major challenge finally.
Okay.
IBC is one only, but I think if you really see the intent or the intention behind that challenge was 29A.
Okay. Nobody was challenging 12, isn't it?
Well, not being challenged.
Okay, so 29A related parties cannot apply, defaulting promoter cannot apply.
Yeah.
That the fact that it has been upheld is very positive.
And 12A, anyway, Supreme Court has already passed a judgment that in one case that even after EOI, 12A can be used.
Okay. Now this upholding of 29A, does it in any way impact the SR case? SR was wanting to, the Ruyas were wanting to apply for it. Because it is upheld, does that reduce their chances in any way?
No, SR is not under 29A. They are not challenging that. They are basically giving a different type of scheme under 12A.
Okay, 12A. And that anyway was not under discussion.
Yeah.
Okay. All right. Gentlemen, thank you very much. Mr. Pramod Dev, Behram Vakil, VG Kannan, RK Bansal, all of you, thank you very much for joining us with your first thoughts. Do we have Mr. Parekh with us? All right. We'll speak with Mr. Parekh a little later. But the verdict quite clearly is very positive news for the financial creditors, for the bankers basically, all of whom are stuck with bad loans, and the moment they want their pound of flesh, there have been competing claims coming from operational creditors, but they will not be entertained by the NCLT. I'm wondering if this has any impact on the Ericsson Arcom case as well, because Ericsson was an operational creditor and they were taking the company to court under the NCLT. I don't know if that has any impact.
Not sure of the impact on the Ericsson case yet, but Lata, the bankers are happy. So if you take a look at all the public sector banks, they're moving higher as we speak. So we have Punjab National Bank, a sharp surge out there. That one's at the high point of the day. We have Bank of India as well moving higher. So the IBC was supposed to give teeth to the bankers, and the Supreme Court has upheld its code, or upheld itself in its entirety.
This is not an earnings accretive judgment. Yeah. It is, ease of doing business kind of judgment. And that, of course, is a longer term and a deeper, wider benefit for the economy.
All right, Lata. Thanks a lot for joining us.